Imagine the Supreme Court in a single emergency order, with barely any briefing deciding whether a president can remove a Federal Reserve governor. That one short decision could instantly rewrite how independent agencies across the government operate. Would the Fed still be independent? Could the administration reshape the SEC or change immigration enforcement overnight? Stick around, because what happens in Trump v. Cook could be the legal earthquake nobody saw coming. Hi, welcome to Shadow Docket, Courtroom Files. I'm host Name. Today we're unpacking why the emergency fight over Trump v. Cook, the case about President Trump's removal of Federal Reserve Governor Lisa Cook, matters far beyond one firing. In the next 12 minutes, I'll explain the legal question at the heart of the case, how the Supreme Court's use of the so-called shadow docket accelerates big legal changes, what this means for the Fed and markets, and why agencies from the SEC to immigration courts could be affected fast. Quick note, this is educational analysis only, not legal advice. This video summarizes news and court filings as of the 6th of January, 2026. Check primary sources and consult a lawyer for case-specific guidance. Let's start simple. On the 25th of August, 2025, the White House announced it had removed Lisa Cook, a Senate-confirmed Federal Reserve governor. 2 weeks later, on the 9th of September, 2025, U.S. District Judge Ja M. Cobb issued a preliminary injunction preventing that removal while Cook challenged it in court. The administration appealed, and after a divided D.C. Circuit panel denied emergency relief, the government rushed to the Supreme Court asking for an emergency order to lift Judge Cobb's injunction. The court didn't immediately decide. It deferred the application and set oral argument for January 2026, which meant Cook stayed in her seat and even participated in October and December FOMC meetings. Now, here's where it gets interesting. The legal fight isn't just about whether this particular firing was lawful. It's about what for-cause removal protections in the Federal Reserve Act mean and whether courts can stop a president from firing a governor while the merits of the case are litigated. And crucially, this path emergency, expedited briefing, quick orders is the shadow docket route. So what's the legal meat? The Federal Reserve Act protects governors from removal except for cause. But what exactly counts as cause? Does it allow removal for conduct that happened before someone took office? Can the president fire a governor for making policy choices the administration dislikes? And critically, if a court finds the removal unlawful, what remedy is available? Can a judge block a firing before it happens, or is the only remedy back pay? These questions matter because they shape the real balance of power. If for cause is interpreted narrowly, meaning the president can fire far more freely, agency independence weakens. If interpreted broadly, presidents face real limits. Numbers matter. There are 7 seats on the Fed board. One swing vote can change monetary policy. Cook staying in her seat while this plays out meant she could vote in October and December. FOMC meetings and markets noticed. Courts have never squarely tested this exact provision for the Fed, so the Supreme Court could be creating first-of-its-kind federal precedent, and if done through an emergency shadow docket order with minimal explanation, we get big change with little reasoning recorded. What is the shadow docket? It's the shorthand for the Supreme Court's emergency orders and short-cycle decisions, the applications, stays, and summary rulings that get resolved quickly and often without full briefing or assigned published opinion. In other words, fast, sometimes cryptic rulings that still carry the court's weight. Why do scholars and practitioners worry? Because when the court decides high-stakes issues this way, it can produce binding effects with compressed briefing, fewer amici, and less reasoning published. That means industries, agencies, and lower courts face sudden changes without a robust doctrinal roadmap. Prior shadow docket interventions have already affected agency actions in significant ways, from election law to public health. Now imagine that power applied to the Fed, the SEC, or immigration enforcement. Suddenly, entire regulatory regimes could be shifted almost overnight. Let's connect the dots. The Fed's independence rests on statutory protections like for-cause removal. If the Supreme Court rules, especially on an emergency application, that a president can remove a governor more easily, the market interpretation will be immediate. Political control over monetary policy has increased. Investors hate uncertainty. Markets that price forward expectations of interest rates, inflation, or central bank credibility could react to both the decision and to the increased chance of politically driven rate decisions. Concrete example. Cook's injunction kept her in place through October and December 2025 FOMC meetings. That meant a full 7-person board and the public expectation that the Fed would act without direct White House personnel manipulation. If an emergency order had removed her, we could have seen abrupt shifts in Fed signaling with consequences for bond yields, mortgage rates, and stock volatility. But it's not only about one vote, it's about precedent. If the court says presidents may remove governors more freely, future presidents might use that power to shape agency personnel routinely, and markets would price in that political risk. This is where the ripple effect becomes a tidal wave. Many federal agencies rely on some version of statutory removal protection. The SEC, FCC, FTC, NLRB, and even some immigration or public health decision makers. If the court narrows for cause, protections, or limits courts' ability to enjoin removals, administrations gain leverage to replace officials quickly, changing enforcement priorities, regulatory agendas, and enforcement independence. Ask yourself, would the SEC's enforcement of insider trading rules feel the same if its commissioners could be removed on political grounds? Would immigration enforcement change if the president could rapidly swap out immigration judges or board members? The practical answer is yes. Policy priorities and enforcement discretionary choices would become more malleable and more political. A crucial legal gear in this fight is remedies. The administration argued that courts shouldn't issue injunctive relief to block a presidential firing, and that any wrong should be remedied retrospectively with back pay. Cook and her supporters argued that an injunction is necessary to prevent irreversible harm, especially when removal's effect is institutional and policy distorting. Why does that matter? If courts are loath to issue injunctive relief in these cases, then removal is effectively irreversible in practice, even if the firing is later found unlawful. That changes incentives drastically. A president could remove at will during litigation, and the affected agency has lost an independent voice for months or years. The D.C. District Court granted a preliminary injunction on the 9th of September 2025. The administration appealed and lost an initial emergency bid at the D.C. Circuit by a split panel. The Supreme Court then deferred and scheduled argument. That sequence shows how quickly remedies can define real-world outcomes even before final merits decisions. This case drew high-profile amici, former Fed chairs, Treasury secretaries, states, and market participants filed briefs explaining the stakes. Former Fed chairs warned that the Fed's credibility depends on protecting decision-makers from day-to-day politics. Their message? Sudden removals produce market turmoil and undermine long-term policy credibility. States and business groups worried about regulatory instability. This isn't just abstract legal theory, it's about real economic actors bracing for policy swings. Let's quickly sum up. 1. The core issue in Trump v. Cook is whether the Federal Reserve Act's for-cause protection limits presidential removals and whether courts can block such removals mid-litigation. 2. The case entered the Supreme Court via the shadow docket, fast-track emergency filings with compressed briefing. 3. The stakes extend far beyond one governor. A binding decision could reshape the independence of the Fed and other agencies, with immediate effects on markets, enforcement, and regulation. 4. The remedy question, injunction versus back pay, is a make-or-break issue for practical independence. Is less than #0.